before the beginning of each presentation. Our first speaker for this session is Associate Professor Dovil Janos. I hope I pronounce it right, but if I'm wrong, I'm sorry. Prof. Dovil served as an associate professor at the Institute of International and EU Law at Mykolas Romeris University in Lithuania. She completed her PhD on the right to housing and continues her research on various aspects of human rights, including human rights in the digital world and the influence of technologies on the protection of human rights. Prof. Dovil is a co-author of several books on human rights, also author of more than 10 articles. She also gave presentations in numerous conferences across the world. For the period of 2014 until 2018, Prof. Dovil served as a legal expert for Lithuania on Franet Research Network. She also participated in a number of research-led initiatives, including projects on the prohibition of forced evictions, protection of migrant rights, freedom of religion, etc. Today, she will present a paper entitled Data Collection During COVID-19 Pandemic and the Human Rights. I think this is a very interesting topic that students should pay attention of. So without further ado, let me hand over the floor to Professor Dovil, who will give her presentation for the maximum of 30 minutes. Prof. Dovil, the floor is yours.
Good afternoon. For us, it's still morning. Just a second, I will. Okay. I would be grateful if you could confirm if you can see my presentation.
Yes, we can see it.
Okay, thank you. Thank you so much. As it was presented by the moderator, today I would like to talk about the data collection during the COVID-19 pandemic and its relation to human rights. So in general, COVID pandemic has raised many issues, not only in the field of health sector, but in human rights sector as well. But due to a very limited time, of course, I cannot focus on many aspects. And I also saw in the program that some aspects have already been raised in other panels by other presenters. So today I would like to focus on very specific aspect on data collection during the pandemic. And I would like to start the presentation with a quote from the Secretary General of the Council of Europe that while the virus is resulting in the tragic loss of life, we must nevertheless prevent it from destroying our way of life, our understanding of who we are, what we value, and the rights to which every European is entitled. There is an urgent need to coordinate states' responses, to exchange good practices, and to help each other in the quest for quicker recovery. And although it was the quote by the Secretary General of the Council of Europe, so it was addressed to the European states, but I think that the quote is relevant for entire world. And even though it's almost 2 years past, it is still relevant. But despite the fact that huge numbers of life losses or threat to life, to health of people, we still, and the states especially, still have not to forget about the human rights. And there is a huge issue and challenge in many countries, how to find this fair balance between the interests of the society and the interests of individual, the interests of human rights. So what we saw during almost 2 years of the pandemic, that it has dramatically changed the way how the states around the world are using technologies in the public health sector, because the virus spread globally, and many states have used various techniques, technological tools and systems to track the exposure of the virus, to monitor the outbreaks, and currently it is relevant to monitor the vaccination, the negative tests of COVID, and so on. And even though on one hand, it is really useful, these tools are really useful because they can be a powerful tools for information, for spreading the information to the individuals among the private sector, the public sector, and like this to prevent the spread of the virus. However, on the other hand, those tools can alert exposed individuals more systematically, and there is the risk of mass surveillance and massive violations of human rights, including the personal data protection and right to privacy. So this is the cartoon, which is, as you can see from the hat, it is for the United States, but I think about this cartoon can be applicable for any state around the world. Just showing those risks and threats, how the collection of data can be treated as a mass surveillance, and there are lots of risks about which I would like to talk more. So, as I said, the tasks for the state, the task for the state, or the challenge for the state is to strike a fair balance between the right to privacy or any other human right of the individual and the interests of the society. Of course, there is no doubt that the importance of those technologies and how they can help to control the virus. But as I mentioned, we cannot forget about the privacy issues and how those technologies can violate and massively violate the right to privacy. So briefly about the legal regulation. So in the classical human rights instruments, we will not find the direct protection of personal data, but we will find the right to private life. So the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, in the regional sector, the European Convention on Human Rights, and other specific documents like Convention of Child Rights and Convention of the Rights of People with Disabilities, and so on. They have the provisions on the right to private life. So even though the protection of the personal data is not guaranteed directly, but all those instruments can be used through the provisions on the protection of the right to private life. And there have been a wide case law, both in the universal level by the Human Rights Committee, as well as the European Court of Human Rights, which used the provisions on the right to private life to protect the personal data as well. But in the European Union, we have a specific document, a European Union Charter of Fundamental Rights, which was actually adopted much later than any other human rights instrument. That's why it allowed this document to be, let's say, more modern and to include not only the classical right and the right to respect for the private life, but also to include the provision, the specific provision on the protection of personal data. And more specifically, in the European Union, there is even a so-called General Data Protection Regulation, GDPR, which entered into force in 2018, which is specifically devoted or focusing on the data protection. And also another aspect which is relevant for the data protection in the and collection of data during the pandemic situation is the right to be forgotten. I'm not aware how far you know about this right, so just a few words. That this right to be forgotten derives from the private life and then a right to privacy, and is related to the data protection. And it is a new developing right because, first of all, the right has been developed by the Court of Justice of the European Union in the so-called Google case in 2014. So in comparison to other rights, it's quite recent, only 7 years ago. But with the adoption of GDPR, this right has been included. So it has now the legal ground. And this right means that individual has the right to ask information to be removed, even if this information is factually correct. So this right is also, as I said, related to data collection during the pandemic, and is important how the states are controlling and retaining and also collecting the data. So it was briefly about the legal regulation or legal grounds for the data collection. And I would like to talk now specifically about the data collection techniques. There have been and still are many apps, programs, websites, and other digital tools used during the COVID pandemic. And of course, it's impossible to analyze all the tools in all the countries, but they can be, the tools, those technical tools can be grouped into some techniques, and I would like briefly to present them. So the most popular technique, which has been used in a majority countries around the world, contact tracing apps. And these apps were in many countries the first ones which were established and then created by, in majority cases, by the states, but also by the private companies as well. So contact tracing apps have been and still are used to monitor or to trace if the person has got positive COVID, what were his or her contacts with other people and where he or she have been. So basically, it is tracing the location of the person and the people with whom this person has been in connection or in close distance, and then these people who were in connection can be warned about the positive COVID test, and like this we can take the preventive measures. Again, as I mentioned at the beginning, the idea behind these contact tracing apps is really positive. The goal is to prevent the spread of the virus. However, there are lots of risks and challenges and threats, because many of those contact tracking apps, they have been created, especially the first ones, 1.5 years ago, without clear evidence demonstrating their efficiency. And they raised many questions about the possible errors, the effectiveness of such programs, and there have been no clear evidence if these apps really achieve their main goal and manages to prevent the spread of the virus. The other issue which has been discussed widely is the collection of data and how it is stored, because in many countries it was the so-called decentralized storing of the data, which was supported by many experts. However, there have been still some countries around the globe who have used the centralized systems and to store the collected data. For instance, Amnesty International has done the analysis, and they identified that Bahrain, Kuwait, and Norway, which is quite surprising, have rolled out some of the most invasive COVID-19 contact tracing apps around the world, and have put many people, or hundreds of thousands of people, and their privacy at risks, because those apps, those applications have captured the location data not through Bluetooth as in many other countries, but used the GPS, and also uploaded the data to central databases, and not only kept the data on the mobile phones. And there have been various issues with those contact tracing apps. And another issue which raises the question about the efficiency is that in majority countries, those contact tracking apps they were voluntary. So it means that each person could decide if he or she wants to download to his or her smartphone these specific apps. And it means that the efficiency of the tracking was dependent, or was depending on the decision of the person. But on the other hand, some countries were placing the so-called mandatory contact tracing apps, and they have been widely criticized for such invasion into the privacy. The other group, which is also related, the help self-reporting apps, but the difference is that here it is not the application is not tracking the location of the person, but the person voluntarily can enter the data, for instance, the symptoms, and like this allow the state to collect information about the numbers of people with symptoms, what kind of symptoms, and at the same time the positive COVID test symptoms. So these applications were slightly different. The quarantine applications, they are also quite similar to contact tracing, but they were specifically focused on the quarantine regulation. So it means that not tracing the people who have been tested positive with COVID and their contacts, but already for the people who must be in quarantine. For instance, it was used in some states in Australia, and it was quite intrusive because they used not only the geographical tracing, but these apps is also used the facial recognition systems, which meant that the person who, for instance, entered the state and had to stay for 10 days or 2 weeks in the quarantine, he or she could be tracked at any time. And these quarantine apps should have helped to show or to prove if the person is at home, because according to the rules, he or she is supposed to be at home. And also the person had to use these apps to scan the face, and like this to show that it's not any other person who is using the phone, but this is the particular person who has to be in quarantine. So it was even more intrusive because it used not only the geographical tracking, but it used the facial control. Another technique which has been used also in many countries, the compulsory registration. It has been used in different ways and in different forms. For instance, in many countries, even now, if you are entering country from or coming from abroad, it doesn't matter, by plane, car, or any other means of transport, you should register. So you should fill the specific form with the questionnaire, if you had contacts with COVID positive tested people, if you had any symptoms, if you have been vaccinated, and so on. But for instance, in Lithuania, and I know that in other countries as well, the compulsory registration at some point was used in very specific sectors. For instance, last year, a year ago, when it was a peak of the second wave of the COVID pandemic, and then the government was still hesitating and didn't want to shut down everything, like to announce this hard lockdown, and still allowed the business to function. But there was a requirement. For instance, if you're going to the restaurant, if you're going to the cinema, museum, or any other public place, or university, for instance, you should register. Okay, if on one hand, we can understand the need for the registration, because it's kind of a bit, let's say, manual way of tracking the contacts, because this is not the apps, but the registration that, for instance, if there is a group of people who have been having lunch at the same restaurant, and after some time, there is information that some of the clients got tested positive, then it is easier to track the contacts of other people who have been having lunch at the same restaurant, or have been in the same movie, and so on. But there is the issue that in this type of tool has been used by the institutions, or in majority cases by the private companies, who normally do not collect data. For instance, restaurants or movie or cinema theaters, museums, and so on. So then the question is how to guarantee that the collected data is not used for other purposes, because it's a great chance for the company to collect the contacts and then to use just for direct marketing, or just to sell it to the third parties. And then in many such institutions, the registration of the data was collected just simply on the piece of paper, writing your name, last name, your address, telephone number, or email. And then there is no information, and there was no regulation how this data has been used, stored, and controlled or deleted. So there have been lots of risks or the abuse of such data. Another technique, drones. So in some countries, drones have been used to monitor how people are following the rules of quarantine and distancing. For instance, drones were flying and checking if people are keeping the distance, because at some point in many countries, there have been really very strict rules that, let's say, only family members could interact, that no bigger, let's say, even 5 or 10 people groups could gather, and so on. So drones have been used to collect such information and to analyze the situation. But again, in those countries where the drones have been used, in majority countries, there have been no specific legal regulation, because drone is flying. So it's not only measuring the distance, but it is collecting the other personal data, the scanning the faces, and so on. So it raised, again, lots of questions about the both efficiency and necessity of such technique. And the last technique, which is especially relevant now, the so-called vaccine passports. There are different names. It can be green passport or certificate, but the idea is that people who have been vaccinated, they get the specific certificate which proves that they are vaccinated, and this certificate is especially now widely used around the globe for people who want to travel, because many countries they require, if you want to enter the country, you have to be fully vaccinated or to provide any other evidence that you had positive, COVID, tested positive and now recovered, and that there are some other requirements or similar documents. But in general, the idea is about the possibility of such people to travel and to get different type of services. For instance, in Lithuania, currently we have very strict rules, because many services can be provided only for the people who are fully vaccinated. So for instance, you can go to the restaurant, to the cinema, theater, to the shopping mall, and to many other institutions only if you are fully vaccinated. But again, there is the issue about the data from these vaccine passports or certificates is collected by the in majority cases by the private companies, which normally do not collect the data. So again, there is the lack of safeguards, let's say, of the abuse of data for non-health related purposes. Because if we have health related purposes, for instance, the person wants to get the surgery in the hospital, so it's I would say normal that the hospital would require the vaccine passport or would test the person. But now what about going to the super shopping mall, and then the employees at the shopping mall are checking your vaccine passport, and they can see your personal data, which normally should not be disclosed. So briefly about those data collection techniques, and I already mentioned some risks, but just to underline what are the biggest challenges and risks with these techniques and data collection. So first of all, the health data is considered sensitive data, and it is now widely collected not only for the medical purposes, but for non-medical purposes as well. And as I mentioned, there is a risk that in the future, it can be used not only for the pandemic situation, but many private companies, they have collected the data and still are collecting the personal data. So it can, as I said, that it can be sold to the third parties. They can be used for the direct for direct marketing in the future, or they can be or I said accessible by the third party, so they can be sold even to different companies, local companies and abroad companies. So it raises many risks. As I also mentioned that in many countries, there is no specific legislation and adequate safeguards which would guarantee that or prevent the abuse of data collection and how the data should be stored, how it should be used, and so on. So of course, now the situation is slightly changing because it has been almost 2 years when we live in the pandemic situation. But especially it was relevant, a huge risk at the beginning, because as I mentioned, that many states, it was the goal or the purpose to prevent the spread of the virus. And first of all, they were thinking how to collect the information and not thinking how later on it will be used, and that the safeguards are needed, that the people should know where their information is collected and where it will be used. So this is the risk for the abuse of collected information. False information. Probably many of you also heard stories how, for instance, person even didn't do the test, but system show that he's positively tested, or he got the information that he's negatively tested, but in the system there was the error that he's positively tested. And at least in Lithuania, we had many stories when person, because of the false information, could not get the services, or had, for instance, to spend 2 weeks in quarantine, even though he was negatively tested and so on. So this is one more risk for the data collection. And also the huge risk, which and issue which is raised by many experts, that this type of surveillance will become normal in the future, so that it will not, that it will extend even after the pandemic is finished. So these are the main risks. Of course, we can be many others, but just wanted to underline and just to sum up and to conclude that, of course, the apps or different other techniques and tools, they are necessary. And in general, I didn't mention it at the beginning, but a right to private life, or right to privacy, or right to be forgotten, all those rights, we are not absolute. So it means that they can be limited. And in general, the state should not be prohibited to collect the data. But when the question is about striking the fair balance between the interests and how this data is collected. So the data should be collected lawfully. It should be limited in scope, as we talked about. It should be, the purpose should be only for the pandemic situation and time, that it would not be prolonged, and it would not become kind of a new normal. And also it has to be specified the legitimate purposes, for instance, prevention of the spread of the virus for the pandemic response. Then such tools should be evidence-based and focus on least restrictive measures. As I talked about at the beginning, many of such applications, they were just created and used without any evidence base if they are efficient at all. Now, after 1.5 years, almost 2 years, of course, we can be more research done, but still it is important to, that as much as possible that these measures should be least restrictive, and just checking maybe there are other ways or other measures possible to use, and not and for instance that those tools would be decentralized and not centralized contact tracing programs. Those tools also should be used to complement and other systems, and also they have to be used together with other measures such as testing, tracing, quarantining, treatment, and so on, so that it shouldn't be the only way or the main way how to prevent the spread of the virus. As already talked, that there is a need for this specific legal regulation, specifically for those tools, how the data could be collected, how the data could be used, stored, and later deleted. And people have to be guaranteed with the safeguards that they can have the right, for instance, to complain and to ask for the erasure of data and so on. And also the requirement of no discrimination against vulnerable groups. I didn't focus more about it, but just to mention, there have been some cases in some countries where those tracking apps have been used or abused even with some discriminatory grounds, for instance, against migrants, for instance, just tracking not only the contacts, but using those apps to track the migration, the migrant workers, and then to give this information, for instance, to the migration department or other responsible institutions. And as I mentioned, this is one of the high risks that the information, the data could be accessible not only for the purpose for the prevention of the spread of the virus, but for other purposes as well. And also, since not only the states, but the private companies are involved, there should be also mechanisms for the transparency and accountability for the non-state actors as well, because there is again a risk that non-state actors or private companies may abuse those tools, those techniques, and as I mentioned, abuse them and use the collected data not only for the purposes for the response to the pandemic challenge, but for the marketing purposes and so on. So just to end with a quote that data protection legislation remains applicable and allows for an efficient response to the pandemic, while at the same time protecting fundamental rights and freedoms. So again, basically everyone talks about this finding of the fair balance between the interests of the society, the prevention of spread of the virus, but on the other hand, to guarantee the privacy of people and protection of their personal data. So thank you very much. And even sorry that I do it at the end, but I just forgot at the beginning. I would like to thank the organizers for inviting me to the conference. It was my pleasure. And of course, I will be happy to respond to any questions, and please accept my apologies for taking a bit longer time. Thank you.
Okay, thank you, Professor Dovile. Do I get it right, the pronunciation? Is it Dovile or Dovile?
Yeah, it's the villa, so he's
Okay,
great.
okay, thank you. Such a nice presentation, Professor Dovili. If I can sum it up, so it is a challenge actually for all of the state in the world that we have to protect the data information relating to human right. On the other hand, we have to keep tracking people where a certain people go and that sort of thing. So it is also crucial for a legal framework and for state to control the pandemic while still protecting the human right relating to privacy issue in data collection. We already have several questions uh, written on the chat from Audrey. She want to ask, apart from the needs of international health regulation and state, need what is the justification on privacy rights protection? And on your opinion, what should be done to protect the rights of personal data? Do you want me to read the questions or you answer one by one?
I think one by one it would
Okay.
be just not to
Okay.
lose the track.
Okay.
So
Yes.
thank you very much, Audrey, for the question. Um, Okay, so I think that the part of the question I have maybe answered with my conclusions or summing up, because I have included some aspects what should be done to protect the rights of personal data. As I said, that there is a need for specific legislation for the safeguards that the techniques or measures we should be used only for the purpose of pandemic prevention of the spread of the virus, that they have to be time limited, that in the future it wouldn't become just a new a normal. So I think these could be this should be done to protect the personal data, and that just to avoid as much as possible the abuse of the collected data in the future. I'm not sure if I got the part about the justification. Maybe Audrey, you could clarify, because I'm not sure that I understand your question.
Oh, yes. Hello, Professor Groville. Yeah, I want to ask that I know that every country now combating with the pandemic. So, is there maybe on your experience, maybe in your country also, what can the state do to protect the privacy rights? And on your opinion also, what should we do to protect adequately the privacy and the personal data? Thank you.
So as I said, that the states should adopt specific legislation which would guarantee the safeguards and would have the provisions how those apps are used, and also that the legislation should address not only the techniques used by the public sector, but also the accountability of the private sector or non-state actors, that there should be specified provisions how the data can be collected, for what purposes, and how it can be stored and used and later on erased, because if from the European Union perspective, as I mentioned, there is this General Data Protection Regulation, GDPR, which is controlling the data collection. But the issue is that the rules for the data control are for the so-called data controller. But as I mentioned, that there is the problem that many subjects which are collecting now the data, they are not considered officially the data controllers. For instance, the restaurants, the cinema theaters, and so on. Normally, they're not data controllers. So from this perspective, they kind of do not have to follow the rules. So there is a need to specify those provisions, that it would be clear that even though in the normal times those subjects, they are not considered data controllers, but in the current, in the present situation, when they are in practice collecting the data, we have to be accountable and we have to follow the rules for the which are applicable for the data controllers as well. And as I mentioned, that the need to prevent that it would not become a normal new future with all those mass surveillance techniques, which should not be used widely, so widely after the pandemic. So I hope that I responded to your question.
Yes, thank you, Professor Dovin. It's very clear.
Okay, thank you, Ms. Audrey. Another question from Nadia Indira. She would like to ask whether does the data collection cases can bring up to the international court beside the third party, maybe can from other countries, and it is possible to access our data. Maybe it's just whether it can be bring to, you know, maybe international court of justice, something like that. I don't, but I don't think so. Yeah. Okay.
Okay. Yes, indeed, and I have no doubt that in the future we will have many cases. The issue is only that the cases by the international courts, they are examined really for a long time. So we will have to wait, I think, at least for 2-3 years or even more to get the analysis for the international courts. So from the European perspective, of course, there will be and already are cases at the European Court of Human Rights, because there is even the case which is what you raised the question about the selling the data to the third parties or to the other countries. So there is a so-called Big Brother case versus the UK. It is not related to pandemic data collection, but is related in general to the mass surveillance and data collection, because in this case, it was raised the question that the UK institutions were providing the collected data, personal data, to the United States Intelligence Office. So I think that at least at the European Court of Human Rights, for sure, we will have the cases. But as I said, currently there are already cases, but in many of them, the applications are just declared inadmissible. But for those which are declared admissible, we will need, unfortunately, to wait at least a couple years to get the final judgment of the court. And then, of course, it will be more easier to analyze. Also, since the data protection and right to be forgotten is one of the aspects which is guaranteed in the European Union law. So I think we will have some cases at the Court of Justice of the European Union as well. As for the International Court of Justice, just a remark that individuals cannot bring the claims or complaints to this court. So it's only the state can bring complaint. So it can be only the cases between the states. So most probably, I would say that in the not in the regional, but in the universal level, there should be some cases at the United Nations level, for instance, at the Human Rights Committee, which monitors how the International Covenant on Civil and Political Rights is guaranteed. So I think in the international, both judicial and quasi-judicial institutions which deal with human rights issues, we will definitely have those cases. But as I said, we will have to wait a bit for the results.
Okay, I think we have one last question from students. Hello, good afternoon, Prof. Dovile. My name is Ranga. I want to ask, what do you propose to address possible misuse of data information? And what criteria do you suggest for legal framework to adequately protect data privacy?
So as I mentioned that the safeguards are needed, that people would have a chance to complain about the collected data, about the usage of data, storing of data. And I'm not talking only about the international institutions, but inside to the national institutions that I do not say that there has to be special institutions created, because just simple existing institutions or the court system can be used, but this is important that the state should guarantee for the people possibility to complain. Then it has to be one of my mentioned criteria is that it has to be limited in time, but it shouldn't be forever, but it has to be devoted only for the pandemic response. So it has to be limited in time, and then the pandemic is over, and I hope it will be over soon, that
Yes.
it will not continue. Those applications would not continue function and collecting data. Then it has to have the criteria of the necessity, that it has to be really necessary in that situations. And necessity means that there are no other options how to achieve the same goals. So proportionality criteria, that again, that those techniques which are used, we have to be proportional for the goal which the state wants to achieve, and that maybe one other criteria, that it has to it cannot be discriminatory, that the application of such techniques should not be specifically applicable to some vulnerable groups, or even indirect discrimination, when formally it is used for all the groups, but it is specifically, for instance, used to track the migrants or so on. So maybe some of these criteria which I have already mentioned.
Okay, I think the time is up, and unfortunately, Professor Claudia cannot be with us here at the moment. So thank you very much, Professor Dovile, to share with us about the data privacy with regard to human rights protection in the COVID-19 pandemic era. So we come to the end of the panel session. I hope what we have today is very useful, especially for students, to to give you an idea of the paper that you should write. So I give it back to the MC, Mbak Belinda. Again, thank you, Professor Dovile. It is our pleasure to have you here, and we are looking forward to have you in Indonesia physically, not only virtually. Okay, Belinda, back to you.
Thank you very
Dovile.
much. Thank you very much. It's my pleasure. And I have been actually at your university a couple of years ago, and it was my pleasure. And I would love to return. And I hope that this pandemic situation soon will be over, and we will be able to return to a more normal
Yes.
life. And I will be able at some point to come again and to visit your university and city. So thank you once again for the invitation.
Thank you, Professor.
Thank you, Prof. Dovile.
Thank you, Ms. Diana Puspitawati and Professor Dovile. Now our event has come to end. We would like to express our appreciation to all distinguished speakers and participants for your presence at this Brawijaya International Law Conference hosted by the Faculty of Law, Brawijaya University. Thank you and see you in our next event. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
See you next time.